Inclusion on page 3, line 9, and then adding in line 11, it would read restraints and involuntary seclusions may only be imposed to manage harmful behaviors or to ensure the physical safety of patients, staff members, or other patients.
Thank you for that update. Jenna, committee, are there other amendments? Senator Baumgartner.
Thank you, Madam Chair. I have an amendment.
Could we pass out Senator Baumgartner's amendment, ladies? Senator Baumgartner, would you like to explain your amendment?
Yes, Madam Chair. It was actually shared with the committee earlier when we had asked if there was any other language in law with regard to restraint and seclusion. And so the revisor plucked that language that had been read to us, and that is what is in the Bloom amendment.
Are there any questions for Senator Baumgartner regarding the amendment, committee? Yes, Senator Petty.
So I will just share that currently in federal rules and regs, when a restraint or seclusion is used for the management of violence or self-destructive behavior that jeopardizes the immediate physical safety of a patient, a staff member, or others, the patient must be seen face-to-face within 1 hour at the initiation of the intervention. So that's federal rules and regs, but there's nothing about the time frame, and this one is 3 hours without medical reevaluation. And does this amendment also mean that restraints can't be used except between the hours of 12 midnight and 8 a.m.? Or I would appreciate explanation. Thank you.
I think that and the revisor can certainly step in as well, but it does indicate the order of a physician that specifies the duration and circumstances under which the restraints are to be used, except in emergency circumstances, until such an order could reasonably be obtained, and so it goes, and the use of restraint or seclusion in a treatment facility should not exceed 3 hours without medical reevaluation, except that such medical reevaluation shall not be required unless necessary between the hours of midnight and 8. So it certainly allows for the use of restraints outside of the hours of midnight and 8. But it does, if the physician does not write the frequency in which the individual is evaluated, it codifies into law that it can't exceed the 3 hours without that.
Other questions for Senator Baumgartner? Seeing none, Senator, are you prepared to move your amendment?
Yes, Madam Chair, I move my amendment.
Do we have a second? We have a second from Senator Stephan. All in favor say aye. Aye. Opposed? That amendment has passed. Committee, do we have other amendments?
Yes, please.
Senator O'Shea.
Thank you. Can I start explaining? Okay.
Let's wait till it's passed out.
Okay.
I started that earlier, and we had requests that people like to see it while you're explaining.
Sure. Oh, can I have? Okay. Thank you. Are you ready for me?
We are ready, Senator O'Shea.
Thank you. So essentially, as I think about this, I think about, there are a few businesses where we say you have to serve every client or customer, whether or not they pay. One of them's public schools, and we fully fund public schools. One of them's hospitals, you gotta serve the customer. And we give them a little bit of money, but I think it's unfair for us to create another rule that might make them lose that money without saying, we're gonna back the money. So essentially what this is, says if for some reason these rules that we're requiring of them makes them lose some of the funding they're receiving, then the state's gonna step in and pay.
Committee, are there questions for Senator O'Shea? Senator Baumgartner.
Thank you, Madam Chair. So out of curiosity, is the obligation for the state to pay if they don't follow state law?
Can the revisor, Jenna, please?
The obligation to pay would be if, in following state law, that behavior would subject the medical care facility to lose federal funding either through Medicare, Medicaid, et cetera.
Okay, so as a follow-up, then does that mean that if the medical facility does not follow state law and action is taken against them, that is the onus of the medical facility to pay?
The language doesn't specify. It only specifies that if a medical care facility faces the loss of federal funding due to compliance with this section, then the state general funds would be used to recoup that lost revenue.
So, Madam Chair, that does not supersede item H, the $25,000 for actual damages an individual sustains.
Yeah, no, this would be separate. Or in addition.
Senator Stefan.
Just a comment, basically what we're codifying here is basic human rights. And, basic human rights granted by the Constitution. The idea that we have a federal administration usurping those rights, it's really, there's not a decision to be made. You don't choose money over basic human rights. I see this as problematic. I see it as morally askew, and I think passing this would be to the detriment of the bill and a detriment to the intent of the bill. Thank you.
Committee, other questions? Yes, Senator Blasey.
Thank you, Madam Chair. And I agree with everything that Senator Stefan just said, which is why I'll second the motion, because what we want to ensure is that when our hospitals are placed between having to follow state law, because there's now a new civil cause of action in this legislation, they won't be having to choose between getting sued in state court with potentially a $25,000 fee or losing federal funding. Medicare and Medicaid, as we know, are huge sources of income for our state hospitals. And in the financial situation that many of our hospitals find themselves in today, we don't want to have them jeopardized. So we want to ensure that they can freely choose, knowing the state has their back, we're all in this together, and we're going to ensure that patients can be visited by their loved ones. But if for some reason CMS decides to bully our hospitals, the state, we're going to be there with them. So thank you.
Other questions? Senator Stefan.
Another statement. I wouldn't go any further than to say it's the threat of loss of revenue from the federal government. There's never been a case of that actually happening. And in regards to the nursing homes, as we heard in testimony, all these agencies came back and apologized to the nursing home for their horrific behavior. So, I think the federal government during this particular administration waged a war of fear and a threat-based war on these facilities, and it's hard to codify protections against fear and threats. And so again, I find this very problematic. Thank you.
My apologies, Senator O'Shea. I did not see your hand.
That's okay, I can comment then on both. If it's only a threat, then it shouldn't be a problem to add it. And secondly, I find the previous argument interesting because it sounds like Medicaid, Medicare for all. If everyone deserves to be treated with human dignity and get health care, that's what I was hearing, regardless of cost.
Let's try to stick to the bill at hand, please, okay? Okay, any other questions regarding the amendment? Senator Thompson.
Thank you, Madam Chair. I'm kind of confused on part of this amendment. It says state general funds shall be used to replace future lost revenues that such medical facilities will otherwise receive. How do you even calculate that? How do you calculate future lost revenues when you don't know how many patients are affected? How many, it's ambiguous. It doesn't make sense to me. So I have a hard time supporting this amendment.
Senator Petty.
I'm sorry, Madam Chair, but usually you've let the maker of a motion respond back to comments that are made by other members, and that hasn't happened with this particular motion. But I will rise in support of this, and that if we are going to jeopardize our institutions to losing, whether it's federal funds under CMS guidelines, which are there in place to provide for critically good care at our facilities, and the reaction of federal government to a pandemic that occurred 4 years ago that we knew nothing about, that we had no past history on, and was carried out under a former president than the current president. But it just shows that when it's important for the health and safety of our citizens of the state of the United States and of Kansas, that's the right decision needs to be made for the safety of all. So this just says that if the actions that are imposed in this bill cause a loss of those federal funds that help to keep those institutions open, then state funds would replace them. I think it's the right way to go.
Senator O'Shea.
I'll move my motion, my amendment.
I appreciate that. Are there any other questions? Yes.
Thank you, Madam Chair. And I too, as I look at this, I'm trying to understand what qualifies as all related expenses. That they would be eligible for all related expenses. Is that defined somewhere else that would define exactly what that is? That's to me awfully broad that someone could claim all related expenses for that.
Jenna, Eileen, do either of you have any responses to that question?
Thank you, Madam Chair. The way that I'm interpreting the drafting would be the related expenses would be modifying all those, the list of things earlier in the sentence. So the civil money penalties, legal fees, revocations of that funding. But it's not a defined term, but the way that I'm interpreting it is the expenses related to the loss of funds listed previously in the sentence.
I appreciate that. It's just that in letter H, we specify, reasonable attorney fees. And, there seems like there's some guardrails around then just all reasonable expenses. That's just kind of vague to me, but thank you, Madam Chair.
Yes, Senator Thompson. I think we have time for one more question.
Yeah, I want to dovetail with Senator Erickson's comments. If you're starting to talk about that, and you're talking Medicare and Medicaid, we could break the bank with one hospital. Not the hospital, the state. Who knows how much money we're talking about, and including future lost revenue. If you had a period of time like we did during the pandemic where they were ignoring these patients' rights over the course of 2 years, I have no idea how this is even workable. That's just my thoughts on that. Thank you, Madam Chair.
Seeing no other questions, Senator O'Shea.
Thank you. I think that's the point, is that we can close hospitals by doing this. If we want them to get in financial trouble and we say you still need to serve every customer, but we're not going to pay anything, they will close. I don't know. I kind of thought that was the point of the bill.
You have moved your motion. Do we have a second? Second from Senator Petty. Committee, all those in favor of this amendment say aye. Aye. Opposed? No. So the chair is uncertain. May I see the hands for those who are in favor of this amendment? Opposed? The chair breaks the tie. I fully understand that there are some concerns that the federal government may say that you cannot allow someone to be with their loved one. I think this bill is too important. And I understand that the hospitals may be concerned, but I can't imagine that they would stand in the way of saying that we will allow a visitor to be able to come. So quite frankly, the chair is undecided. The purpose of this bill, and I think we can all in this room and in this committee agree, is to allow people to be with their loved one, not have anybody die alone. I'm sorry. And I think we need to keep the focus on that. But I think it's way too broad and could be any, is the onus on the hospital to have to prove that because of this ruling, thank you, that because of this ruling, X amount of dollars would have to be paid by the state, and how do we know that that is what specifically caused them to have to pay for dollars? And thank you. I feel that it's too broad. If there was something I think that was more narrow, I'd be in favor of voting for that. But I find this particular amendment too broad, so I will vote against the amendment. Committee, we were back on the bill. Do we have any other amendments? Question, Senator Holscher.
Yes, thank you, Madam Chair. My question is probably for Jenna. Sorry to interrupt you too. At the heart of this bill, when we were first talking about this, there were a lot of individuals who testified in favor of the bill, and some of them made charges of, I would say, abusive behavior. My question is this: is there anything in statute that would prevent family members from prevent families from taking a family member from a facility if they had concerns?
Yeah. Yeah, thank you, Madam Chair. It's my understanding generally that a patient could be discharged against medical advice. That there may be instances regarding transport that may be necessary if someone is on a certain ventilator or something that would make it unfeasible. But I don't believe there's anything in state statute. There are state statutes. There is a specific one relating to refusing care, related especially to a person who's terminally ill, relating to refusing care and being removed or leaving a hospital at the end of your life.
Okay. And the reason I ask that is because I do know of a couple of situations where people maybe were not in agreement with, kind of similar to some of the people we heard the other day, but there was nothing that prevented them from taking their family member from a facility. So like I said, that's why I asked that question.
Thank you, Senator Holscher. Committee, we are back on the bill. Do I have a motion regarding the bill as amended? Senator Steffen.
Make a motion that we pass the bill as amended favorably.
Do we have a second? Second by Senator Thompson. All in favor say aye. Aye. Opposed?
No.
The ayes have it. 352 is passed out of committee. Committee, I would like next to address your attention to Senate Bill 391. Oh, I'm sorry. Yes, you may be recorded. I'm sorry, I thought. Do we have any amendments or discussions on 391? Yes, I see your hand. I, however, do have an amendment, and we'll start with that amendment. Committee, as I see this bill, it is allowing the same, our Department of Health and the medical director, the health directors in our counties, et cetera, to be exactly what our CDC, to follow those same rules, which is the intention, which why you see recommend throughout this bill. The only thing that I'm looking at here is on the bottom of page 2. It had been stricken, licensed social worker, teacher, or school administrator was not required to report. I believe that having been a classroom teacher, I think teachers will report anyway, and so I think that we should just leave that in there and to allow those licensed workers and teachers and school administrators, not allow, but require them to, so that the department has the data that they need. Then on page 4, again, we want to say for the protection of public health, control of infectious or contagious diseases, the Secretary of Health and Environment shall designate such diseases that are infectious or contagious in their nature. They are capable of designating that and have the expertise to do so. On B, the Secretary of Health and Environment is authorized to recommend ways to prevent the spread and dissemination of disease injurious to the public health, including but not limited to providing for the testing for such diseases. That doesn't mean people have to take them. They can provide that testing and may recommend the isolation and quarantine of persons afflicted with such diseases. And then on page 5, there has been some discussion regarding Section 8, and it does say, is hereby amended to read as follows, that it shall be unlawful for any, this was in current law, shall be unlawful for any public or private employer shall not discharge an employee solely because the employer, an immediate family member of the employee, is under an order of quarantine or isolation. That's the way the current law reads. I'm asking that we keep that as in current law and not make any adjustments to that. And are there any questions regarding the amendment? I'll second it. Any questions regarding the amendment before we vote? Senator Baumgartner.
Thank you, Madam Chair. These are quite a few amendments. Can we go page by page, vote on them page by page?
Begin by asking if you have a question about each one of them in particular, or?
Well, I mean, you've indicated completely striking out Section 8. And that Section 8 is not necessarily directly related to some of the other sections. And
All right,
that's why I asked if we could vote separately.
I'm fine with that. I just wanted to make sure that there were no questions initially. So we'll go with page 2, page 4, and page 5. Senator Baumgartner?
That'd be great. Thank you,
Okay,
Madam Chair.
absolutely. So I will move a motion that we accept the amendment on page 2. Senator Blasey, do you keep your second? Senator Blasey has seconded that. All in favor of that, say aye. Aye. Next, we will go to page 4. Any questions on page 4 before we vote? Senator Petty.
So I would just appreciate if the revisor could go over these 4 different boxes as it plays out on page 4.
Jenna?
Thank you, Madam Chair. So the first box, I guess it is striking the language in subsection A relating to submitting a report to the Speaker of the House and the President of the Senate, and it just restores the word designate. So the Secretary of Health and Environment would designate a list of diseases that are infectious or contagious. They would not be rules and regulations. They would just be a list that is made up by KDHE. The 2 boxes with the italics are just notating where language has been stricken. So there's in 26, 27, 28, and 34. And then in subsection B, it is restoring the language of current law, which would allow the Secretary of Health and Environment to test for diseases.
As a follow-up.
Sorry, Senator Petty.
Thank you. So Jenna, then in dealing with the, in line 25, I guess it starts there, and then on to 26 about designating, but you're saying that we still have stricken the by rules and regulations. So then this basically would mean that the Secretary of Health and Environment would prepare a list that would just be available, but it would not be enforceable in any way through the health departments?
Generally speaking, yes, it would not be enforceable except for within the department itself. So it could govern intra-department policies, but it wouldn't have the force and effect of law that rules and regulations do.
So if I may, Senator Petty, if you look on line 26, it's just restoring current language that begins with the word designate.
Thank you, Madam Chair. I see that. But to me, just putting in the word, putting back in the word designate is moving in the right directions, but having a list that's just a list has no any real value for our families in Kansas.
Again, this amendment restores designate and the remainder of down to through line 27 that is in current law. Other questions, committee? Senator Holscher.
Thank you, Madam Chair. Jenna, can you elaborate for me too? I just want to make sure I'm understanding this correctly. With this amendment, as we go further down, this still just keeps the power to be making recommendations, correct?
Correct. Except for, I guess, the secretary would be allowed to test for such diseases, if samples were submitted to their labs, things like that.
Seeing no other questions, I move my amendment. Do I have a second? Senator Stephan. And the committee, all in favor of the amendments on page 4, please say aye. Aye. Opposed? Now we are moving to page 5. On page 5, it is just restoring the current language for section 8, reverting back to current law. Any questions on that? Senator Thompson.
Yeah, the way it's on line 41, it's struck out under an order of, is that the current law or is following an isolation or a quarantine?
If you read it, it says that an employer, shall be unlawful for a public or a private employer shall not to discharge an employee solely because the employee or an immediate family member of the employee is under an order of isolation or quarantine.
But if this...
If he were, the employer cannot
Got it.
let it go. That's in current law.
But are we not under the order of whom? Because it wouldn't be under the KDHE because they're just recommending.
Correct, it's not under the order of KDHE.
So it'd be
Just
under
if they
the
were
order
under,
of-
let's say they were under federal order. Just if they were under any order, that's in current law. We're just restoring current law.
Okay. I just wanted to
Eileen?
make sure I was clear.
Eileen, would you say that in the mic?
Thank you, Madam Chair. I was just, I wanted to bring up the point that perhaps it's an individual who has measles or something like that, and their family doctor is telling them to stay home. That would be applicable here as well. I apologize. What I was saying is that this portion that says is under an order, it could be a family physician treating an individual because the individual has measles or has been exposed to something and is recommending that the individual stay at home for a certain period of time. That would be applicable under this as well.
Any other questions? Senator Petty?
Madam Chair, could staff just read the current law as it would read?
Thank you, Madam Chair. 65129D currently reads, "It shall be unlawful for any public or private employer to discharge an employee solely because the employee or an immediate family member of the employee is under an order of isolation or quarantine. The violation of this section is punishable as a violation of KSA 65129 and amendments thereto."
Thank you.
Committee, I move my motion unless there are other questions. Seeing no other questions, do I have a second? Oh, I'm sorry, Senator Baumgartner, I missed your hand.
Thank you, Madam Chair. Just wanted to make sure that by approving this, we are striking line 43 with the exception of the violation of this. So what is in italics on line 43, 42 and 43 is struck completely from any consideration. Is that correct?
Yes,
Thank you.
I'm sorry, we had a second? Senator Blasey. Committee, all in favor of the amendment on page 5, say aye. Opposed? No. All right, so that amendment does not carry. Okay. All in favor of the amendment, please raise your hand. 2. Opposed? Same sign. We have 5 opposed, so the amendment does not carry. Senator Petty, you had an amendment.
I did not put all of mine together. I have separate ones.
I'm sorry.
You put all of yours together. I have several, but they're separated. So if you look at the amendment, it's striking the new section 1, which would remove the name for this bill. This is not we are not changing our constitution. It would renumber the sections accordingly.
Any questions on the amendment? Senator Stephan?
Thank you. Constitutional Right to Health Freedom Act. This moves us to the constitutional model of public health. The names flow very nicely, and I don't think there's anything to be gained by striking that out. I think it is a nod to the fact that we are moving to the concept that public health follows the Constitution and doesn't impose mandates on individuals. So I'm against the amendment. It detracts from the overall integrity and intent of the bill.
Other questions, committee? Seeing none, you may move your bill, your amendment.
So those comments are interesting because I think that we do have in Kansas quality health care, and this implies in many ways that we don't, and that we want to continue to look back and not forward for the health care of our citizens. And I think that our healthcare providers, whether we're talking about hospitals or nursing homes, all attempted to provide the best and safest environment for all of them, and did it with as the least amount of knowledge as we all had. Looking back is always, the armchair quarterback always has a better view than being right there at the time. This title implies that somehow we don't right now have health freedom in Kansas, and we do. I move my amendment.
Is there a second for the amendment? Senator Holscher. Committee, all in favor of the amendment, say aye. Aye. Opposed, no? No. The noes have it. Senator Petty, do you have another amendment?
I'm going to let Jenna explain this one.
Thank you, Madam Chair. This restores some of the initial numbering and strikes the criminal penalty in line 32 related to a violation of the provisions of KSA 65116A through 65116M relating to tuberculosis.
I'm sorry, Jenna, could you say one more time?
This would strike the criminal penalty. It's in line 32 currently, relating to a violation of the statutes listed in line 23, KSA 65116A through 116M, relating to tuberculosis, so that if a person were to violate the a tuberculosis institution quarantine, or yeah, there's some purchasing or payment issues relating to persons in a tuberculosis facility, which I don't even know if we have those anymore, that there would no longer be a criminal penalty associated with violation of those statutes.
I guess I'm a little confused. So the tuberculosis segment has been in law since 1917, right?
Thank you, Madam Chair. I don't know if all of the sections listed are. The first one I looked up has been in law since 1957. But the addition of the criminal penalty, you'll notice, is in italics. So that was added in this bill. So this would restore to current law that it would just be unlawful to violate provisions of the act.
Committee, are there other questions regarding this amendment? Dr. Stephan.
Thank you. It was my understanding that the tuberculosis section wasn't touched at all in this bill. Can we kind of verify that that happened?
The statutes referenced in this section, the statutes 116A through 116M are unchanged. The only one that is amended is this KSA 65116G, clarifying that the provisions of this act are related to tuberculosis, and there's some cleanup, and then clarifying the criminal penalty.
I think there's some confusion. I'm confused as well because I understood that, yeah, Eileen.
So in section 3, the statutes KSA 65-116A through 116M are unamended. What has been amended is to establish the criminal violation, to make it a Class C non-person misdemeanor to violate any of those statutes, 116A through 116M. What you're seeing, there's a lot of striking because subsection B was the violation, and if we strike subsection B, as we know from outlining class back in whenever, if you have an A, you have to have a B, but if you lose the B, you have to lose the A with it. So then the 1, 2, and 3 that went with subsection A now turn into A, B, and C because we no longer have those A and B designations from before. So really, all we're doing is just striking the fact that there would be a violation that would be the Class C non-person misdemeanor. The underlying statutes remain unchanged.
So again, I'm so sorry, but I thought they were unchanged in the in the bill, in the amendment. And they still are unchanged. So then what does this do?
This would take away, it's striking in line 32, that violation of this section is a Class C non-person misdemeanor. Section 3 in the bill clarified, because initially it said if you violate the provisions of this act, it was unclear what this act referred to. And so it was added to reference these old statutes relating to tuberculosis. And so this would just strike the criminal penalty that was added in Section 3.
And it was added in section 3 to make sure that it was just regarding the tuberculosis, because we wanted that to be unchanged. So if this amendment was voted down, it would still leave the tuberculosis section unchanged in current law, go back to current law. All right, thank you for that. All right, committee, any other questions? Senator Petty.
If this amendment were voted down, it would go back to current law. It's not correct. It would go back to the bill as written.
The criminal penalty would go back to current law. The rest of the statute would remain as it is in the bill.
All right, thank you.
Senator Petty, do you move your motion? Or do you move your amendment?
I move my amendment.
Yes, do we have a second? Senator Holscher. Committee, all in favor of this amendment, say aye. Opposed? Okay, the chair is undecided, so if you're against this amendment, or you're for this amendment, please raise your hand. 2, 3, 4. Against this amendment? Seeing 2 hands, so the amendment passes. Senator Petty has another amendment.
Jenna, would you go ahead and share about this amendment, please?
Thank you, Madam Chair. This would make changes in Section 6. It would strike all the language in subsection A so that the Secretary of KDHE would no longer be required to make a list of the infectious or contagious diseases and restore the Secretary's authority to current law in subsection B, that the Secretary could issue rules and regulations as are medically necessary and reasonable to prevent the spread of diseases, injuries to the public health, and to isolate and quarantine persons afflicted with or exposed to such diseases. So it would strike all of subsection A and restore subsection B to current law.
Senator Petty, do you have anything to add?
No, I think Jenna did a great job there. If we really are interested about providing for the health of our Kansans, it's important that the Secretary of Health and Environment has the authority to adopt those rules and regulations that help to make that information available and worthwhile, and put in place so that whether my child's going to daycare or whether my children are going to school or I'm going to work, I can feel somewhat confident in being in a healthy environment.
Are there any comments, committee? Senator Thompson.
It seems to me like this undermines the whole bill. It just restores the authorization of the secretary to do whatever she wants to do, which was the whole intent of the bill in the first place. Thank you, Madam Chair.
Yeah, Senator Stephan.
Thank you. Medically necessary and reasonable to prevent the spread and dissemination of diseases. We saw what effect the mandates had on our society. It destroyed a society. It curtailed education. It led to increased suicide. It led to education losses. The collateral damage was huge. So to restore their ability to have the opportunity to do the same thing over again is absolutely against the intent of the bill. This bill brings humility and sincerity to the KDHE in that they have to talk to people, educate people, and not rule over people. So please, let's not support this amendment. Thank you.
Senator Baumgartner.
Thank you, Madam Chair. This committee has already taken action on amendments for Section 6, so I'll be opposing this proposed amendment.
Senator Petty, are you ready to move your amendment? Yes, Senator Holscher.
This might be a Jenna question again. Didn't we, or maybe it's just a recollection, didn't we talk about the fact that this bill ties to issues with COVID, but it's no longer a reportable disease, and we currently don't have any requirements or mandates in place. So I think that's at the whole heart of the issue. We're addressing things that aren't in place at this point. So this amendment does make sense in that regard.
Thank you, Madam Chair. I believe your recollection is correct that the KDHE Secretary specified that COVID is no longer a reportable illness.
Senator Petty, are you ready to move your amendment?
I am ready to move my amendment. I move my amendment.
Do you have a second? Senator Holscher. Committee, all in favor say aye.
Aye.
Opposed? No. Noes have it. Committee, I have an amendment. Are there other amendments? Therefore, I believe this is the last amendment on 391. We heard when I carried a similar bill on the Senate floor, some concerns about if, like with CDC, the CDC can make recommendations, but who can determine someone needs to be in isolation or someone needs to be quarantined, as we've had, let's say we had an outbreak of Ebola or something of that nature. So this amendment addresses that. So again, we have recommendation, recommendation, and recommendation, But then we would add that the local health officer shall submit recommendations related to the isolation or quarantine of individuals under this section to the Board of County Commissioners to keep it local. At the next regularly scheduled meeting of the board or at a special meeting of the board shall review such proposed order and may take any action related to the proposed order of the board determines as necessary. The order shall become effective if approved by the board or if the board is unable to meet, if approved by the chairperson of the board or the vice chairperson of the board. So it's not the local health officer that's giving orders. It is not the KDHE giving orders. They are to collect data and do research, but they may make recommendations. And any isolation in the unlikely event that should occur would only come from a local health officer because it's a local entity. Questions? Pardon me. Senator Thompson.
If I read this correctly, though, the board shall review an order and take action related to the proposed order of the board, and the order becomes effective. So even though the local health officer is recommending, a board would order or could make an order. And I think my concern is that these boards followed recommendations from on high and it trickled down, and they were quite hesitant to go against recommendations. And therefore, it has the de facto effect of an order, even though it's not. That's my concern.
I understand your concern. I share some of those same concerns. We want to make it clear that it's not a rule or a regulation, but a recommendation. So it's a recommendation of a proposed order. So let's say that in an area, there's been an Ebola breakout of 5 people. And the local health officer could say, we have had a breakout. My recommendation would be that we isolate these people that have had this. So then they could make the order that if you have this disease, you should be isolated. Again, very rare situation. I think we've had that with tuberculosis, and Jenna, we talked about, and Eileen, help me with another time that the United States has ever, that anybody has had to be isolated or quarantined. So people have concerns. Somebody needs to be able to make that order. And when have we ever done that? Spanish flu in 1917. So in the unlikely event that that should need to occur, we do have an entity that could determine that or make that order. Other questions, committee? Yes.
I just wanted to add that this language that was added in this, or the proposed language, mirrors the language that was adopted by the legislature in 2021 in KSA 65201 relating to local health officers and the wearing of masks. And so the language of going to the county commissioner and asking them to approve a proposed order, it mirrors that language already in current law relating to KSA 65201.
Okay, committee, we are very close on our time, and I want to make sure we get down to the floor. Senator Stephan.
Thank you. You know, my concern with this amendment is that it defeats that idea of putting the KDHE into a educational mode. You know, now, and again, it gets back to that sincerity and humility I talked about that they needed and they need. They're a marketing firm. They really are. They need to market to all the citizens. This narrows their marketing down to the county health director and to the county commission. It takes the private citizen out of their marketing campaign. It takes the sincerity and the humility out. I strongly believe that this is not what the grassroots citizens of Kansas want to see. This too is a backwards movement away from our constitutional rights. So I can't support it.
I would just direct attention to the fact that it's specific to isolation and quarantine of, and my apologies because I actually wanted to have affected individuals in there. We don't want anybody isolating or quarantining supposedly or might be people, but people who have, and again, the last time this was used was in 1917. But thank you. Committee, yes, Senator Petty.
I strongly object to the Kansas Department of Health and Environment and my local health department being referred to as just a marketing firm. The Kansas Department of Health and Environment and my health departments and all the health departments in Kansas are there for a very specific reason, and that's to provide access to variety of health information
noted.
and
Thank you, Senator Petty.
materials.
I'm so
Well,
sorry
if
we're-
those things are said in this committee, I'm going to say the right thing.
Let's move on. So committee, I have moved and I have a second on the amendment. So all in favor of the amendment, please say aye. Opposed? So committee, the chair is undetermined. Can I see the hands of those who are for the amendment? 1, 2, 3, 4, 5. Those that are against? The amendment has passed. We are back on the bill. Do I hear a motion that we pass the bill as amended? So moved by Senator Stephan. We have a second. Second from Senator Thompson. All in favor of Senate Bill 191?
You didn't ask for,
391, thank you. All in favor of Senate Bill 391, please say
you
aye.
didn't ask for discussion.
I'm sorry.
Point of order.
Okay, we have time for 2 people to discuss. We need to get down on the floor, and we need to finish this. This is our last day. So,
I do have a question that's very important. We didn't even discuss the fiscal note at any point on this bill, did we?
there was no question about a fiscal note on this bill.
Okay, because I do think that is something that needs to be considered. I mean, this is a very hefty cost in terms of potential changes from this bill.
Okay. Duly noted. Yes, Senator Blasey.
Thank you, Madam Chair. I appreciate the spirit of the bill, and I will be opposing this bill because of Section 8 still remaining in the bill. I had every intention of supporting it, but as we continue to expand employer mandates and really in this bill create a new employer liability where our child attorneys will have a field day, I will have to oppose this bill in its current form. So thank you.
So committee, all in favor say aye. Aye. Opposed?
No.
May I see the hands of those that are in favor of the bill? Seeing 4, opposed? Seeing 4. The chair is for, breaks the tie, and the chair is for the bill. Senate Bill 391 passes out of committee. Committee, before we leave, I'd like for us to turn our attention to Senate Bill 433. It was the one, if you recall, that only added the "and." And I heard from the Department of KDADS this afternoon that they were the only ones that opposed the bill, and they now understand it and no longer oppose the bill. And our I thought it was KDADS. Was it KMS? Okay, my apologies. Thank you.
Move that we pass out Senate Bill 433 favorably for passage.
Way to go, Senator Petty. Can I have a second? All in favor say aye.
Aye.
Opposed? Senate Bill 433 is passed committee. This hearing is adjourned, or this meeting is adjourned.